Huge breaking news today out of the federal court system involving our Second Amendment rights. The Third Circuit Court of Appeals, based in Philadelphia, Pennsylvania, heard 90 minutes of argument about the definitions and scope and meaning of our right to keep and bear arms under the Second Amendment, with Joe Biden's Department of Justice on the one hand and Second Amendment advocates on the other hand fighting it out in court in a case involving a nonviolent felon who has been denied his Second Amendment rights for almost 20 years. Stay tuned. We're going to break it down for you when we come right back. Hey folks, it's Mark Smith here, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and New York Times bestselling author. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. Okay, major breaking news. I just listened to 90 minutes of oral argument in a case called Bryan Range versus Merrick Garland and the Department of Justice in the United States of America. Mr. Range has sued seeking to get his Second Amendment rights back. He argued that under the Second Amendment, a crime that he committed 20 years ago, and since then he's lived a law-abiding, honest life, so according to the allegations, and he claims that under the Second Amendment, Congress applying the statute of 18 U.S.C. 922G cannot deprive him of his Second Amendment rights. We sometimes refer to this kind of a case as the Martha Stewart case, where you have someone that has pled guilty to a crime that Congress has defined as a felony, but has no connection to violence or dangerousness, and whether or not that is a basis for people to lose their right to keep and bear arms literally for the rest of their lives. So Bryan Range brought this lawsuit saying that he's not a danger to society, he's never been a danger to society, he's never done anything violent in his life, and yet he's been denied under federal law, 18 U.S.C. 922G, of his right to keep and bear arms for life. And that is unconstitutional under the Second Amendment, under the Heller case in 2008, and under NYSERPA versus Bruin. Joe Biden's Department of Justice has robustly argued that this guy is entitled to no Second Amendment rights because Congress, that's right, Congress and legislative bodies around America have the right to determine who gets the right to keep and bear arms. Even though the Second Amendment is a fundamental constitutional right, which is in the text of the Constitution, and the Supreme Court has repeatedly called this a fundamental constitutional right, the Department of Justice today took the position that no, Congress and state legislatures get to determine who are quote-unquote trustworthy and law-abiding citizens entitled to keep and bear arms. Now, this was robustly argued and disputed by the plaintiff's lawyer on behalf of the Second Amendment, arguing that that is not the way to look at the law, that deferring to the legislative bodies, deferring to Congress and to state legislatures as to who has the right to keep and bear arms is simply anathema and completely inconsistent with any and all fundamental rights under our Constitution. Bryan Range's attorney argued that the way to interpret the Second Amendment after NYSERPA versus Bruin is actually consistent with the way we've talked about on this channel. He made the argument that the right of the people to keep and bear arms, in this context of whether or not a nonviolent felon gets his or her rights back under the Second Amendment after he's been convicted of a crime, turns on, first of all, who is the people, right? The right of the people to keep and bear arms shall not be infringed. And the plaintiff's lawyer there on behalf of Mr. Range says the people includes all American citizens, not just law-abiding citizens, not just virtuous citizens, but all citizens at the first level, at the plain text level. And once that includes Bryan Range, the plaintiff in this case, then the burden shifts. I repeat, then the burden shifts to the government to come forth with historical analogs at the time of our founding of 1791 to show that there is a long-standing historical tradition of laws that disarm people that have committed crimes. So what happened here in the Third Circuit oral argument, which went on for about 90 minutes, by the way, the Department of Justice really was unable to identify any historical analogs of people that had committed a crime and lost their gun rights. He did say, the lawyer for the Department of Justice, who did a reasonably good job, did point out, though, that even though the first statute in American life that says that the individual loses their gun rights for committing a crime arose in the 1930s when Congress passed a relevant act, he said that there are analogs going back to the founding period, and that involved, for example, Obviously, there's laws involving, blacks could not have guns, Catholics could not have guns under certain circumstances, and of course, loyalists that were loyal to the British government during the American Revolution, they could not have guns. And the government's argument basically is that there are deeply rooted history here of taking guns away from people that Congress or legislators decided were, not only dangerous, but also could be not law-abiding and not trustworthy. The Second Amendment plaintiff's lawyer on behalf of Mr. Range says, no, if you look at this historical analogs, every single one of them turned on the notion of dangerousness. In other words, a person has to be dangerously violent before you can disarm them. And the example was, even if you look to arguments against the loyalists, the argument was that when a loyalist at the time of the American Revolution refused to swear an oath to the new United States country, they were deemed a loyalist fighting for the redcoats and were thus dangerous to the new country. And that is the argument that Mr. Range's lawyer argued as to why, if you're not dangerous, they simply cannot take away your right to keep and bear arms. The lawyer for Mr. Range also made a powerful argument that says that the word the people, right, the word the people does not just appear in the text of the Second Amendment, it also appears in the text of the First Amendment. It also appears in the text of the Fourth Amendment. It also appears in the text of the 14th Amendment. And therefore, it would be improper to interpret the text of the Second Amendment narrowly by adding the words law-abiding people to get your right to keep and bear arms, when the word people in the First Amendment dealing with the right to, free speech and the right to religion. I mean, certainly if you're convicted of any crime, you still have the right to free speech and you still have the right to practice your religion in the First Amendment, talking about the people. And likewise, the Fourth Amendment, talking about the right of the people to be free from unreasonable searches and seizures in the context of, let's say, criminal matters. Again, no one suggests that the people in the text of the First Amendment dealing with free speech, or the people in the text of the Fourth Amendment dealing with unwarranted searches and seizures, is somehow a different group of people than the right of the people to keep and bear arms. And I thought that was a very powerful textual argument on the part of Mr. Range's Second Amendment attorney. And in light of that, and I think the court, my view is the court was very sympathetic to that notion that all the people fall within the definition of people in the Second Amendment. So then, once that happens, as you know, when the plain text is implicated, and here it is, because once Mr. Range falls within the definition of the people, as in the right of the people to keep and bear arms, then the burden shifts, and they're trying to take away his right, which of course infringes on his right to keep arms, as well as his right to bear or carry arms. Once that happens, the Second Amendment is triggered, and when the Second Amendment protections are triggered at the plain text basis, what happens? You know what happens, which is that the burden of proof to come forth with historical analogs of showing a long-standing tradition of taking away gun rights shifts to the government. And that, in this case, is Joe Biden's Department of Justice. And the lawyer, again, had to try to point to historical analogs. And I think that what he basically tried to do, and I'll try to put a link to the argument down below. If I get access to it, I think I should be able to. But what he was trying to argue is, if you look at the Supreme Court's decision in Heller and Bruin, they make references to felons in possession laws are presumptively constitutional, and he was trying to rely, I think, heavily on the case cites to Heller and Bruin and that language that we find in Heller, that, again, laws forbidding the possession of felons to be presumptively constitutional, and he was right to rely on that. But of course, the problem is, and one of the judges pointed this out, was, well, doesn't it say presumptively lawful under the Second Amendment to take away someone's rights because they're felons? But something that's presumptively lawful doesn't mean it is lawful. It just means it seems to be likely lawful, but it wasn't actually ruled upon. And now in the Range case before the Third Circuit, it's going to get ruled upon. So I think that's very important that's going on here. I should also say that the other argument that Joe Biden's Department of Justice made here was they were trying to argue that, look, it's simply going to be too hard to make individual determinations that you or that I or that someone down the street is a danger to society. It's going to create too much work and be too hard for courts, which are government courts, to do this work. Now, Mr. Range's attorney, I think, did a good job responding to this by making several observations. First of all, he says, well, courts make hard, individualized determinations about whether or not you and I are dangerous every single day. For example, when they set bail. So someone gets arrested, they have to determine whether or not, A, they get bail, and if they do get bail, what's the bail going to be? That is an individualized determination of various things like, is he going to leave the country? Is he got a lot of money? Does he have an incentive to run away and not be tried? Is he dangerous to society? So they're already making determinations about dangerousness at bail hearings. Also, when someone is sentenced to prison, there's a determination whether or not they are dangerous to society or something like that. All these individualized determinations play in to whether or not a person is dangerous or a risk to society. And I think that's true. So simply because Department of Justice says it's going to be hard to determine who is a danger to society as opposed to simply a lawbreaker, really at the end they shouldn't matter. And if you recall, in the Fifth Circuit Court of Appeals decision in favor of the Second Amendment in a case called Rahimi, United States versus Rahimi, just a few weeks ago, what they specifically said is you cannot defer to Congress and the legislatures to define whatever they want to be a felony, because as you know, under federal law, 18 U.S.C. 922G, it says that if you've been convicted of a felony as defined by either a federal felony or a state felony, which is defined by a crime labeled a felony, plus you could be sentenced to prison for a year or more, or you've been convicted by a state misdemeanor where you could have been, not that you were, but that you could have been sentenced to prison for 2 years or more, even if you weren't, that falls within the definition of felony under federal law 18 U.S.C. 922G. And basically DOJ is saying, well, Congress gets to make that judgment call as to what's a felony. They get to define it, and you federal courts have to defer to that. And of course, the courts, and I can see the judges were kind of saying, well, that's not really how the Constitution works. If there's an ambiguous situation or a close line call about what's constitutional and what's not, the presumption always goes to the constitutional right. In other words, if it's hard to figure out if something is legal or not, or constitutional or not, the tie goes to the American citizen. It doesn't go to the government. And if something's hard for the government, so what? Because remember, the whole point of the Constitution and the Bill of Rights is to make the job of the government harder, because the harder the government has to work to take away your individual rights, that's what we want. Because certainly if all we want to do is make life easier on the government, I'll tell you an easy way to do it is get rid of the Bill of Rights when it comes to all those criminal, procedural hurdles. Get rid of the right to trial by jury. Get rid of unreasonable searches and seizures and just say, hey, a government can walk in anybody's house at any time and look through their stuff for evidence of a crime. Get rid of the right against self-incrimination. Just make people talk and say all sorts of things. Yeah, if you got rid of all that, you would make life a lot easier for the government to do its job, but that's not the purpose of the Bill of Rights. The whole point of the Bill of Rights is to make it harder on the government so our individual freedoms are protected. And that's inconsistent, as I see it, with what the Department of Justice was arguing in the Range versus United States versus Garland case here today in the Third Circuit. Okay, so my final point, because I know you're going to ask me this, is who's going to win this case? I think in this case, this is my prediction. We're not going to know about this for several months, but I think the plaintiff, Mr. Range, is going to win this case. I'm pretty sure I'm right on this. But it's going to be a little confusing what it means for our Second Amendment rights, and I'll tell you why. The best evidence that I think that Mr. Range is going to win this case is that this is an en banc oral argument, which meant that several months ago, when we covered this on this channel, Mr. Range, again, went before a 3-judge panel in front of the Third Circuit, and that 3-judge panel, the initial panel, ruled against him 3-0, and they did it after Nyserpa versus Bruin, and basically said that under Bruin, we think Mr. Range is not entitled to his right to keep and bear arms. The entire Third Circuit Court of Appeals, of which I believe there are 15 judges today, decided they wanted to hear the case as a full court. So all 15 judges today heard today's argument en banc. So the first evidence is that Mr. Range, I think, is going to win is the fact that you had a 3-judge panel that ruled against Mr. Range, and now they're hearing the case. Why would you want to hear this case if you're just going to affirm the lower court the panel decision? There'd be no purpose for it. So that's the first evidence I think Mr. Range is going to win. The second evidence that Mr. Range, I think, is going to win this case specifically is a series of questions asked by Judge Jane Roth. Now, Judge Jane Roth is very interesting. She's now a senior judge, and this is going to get a little geeky. a little geeky, but I think my analysis is right on this. Judge Jean Roth is a senior judge. I'll tell you why that's important in a second. She sat on the lower court panel. She was one of the 3 judges that ruled against Mr. Range on the panel, saying he did not have a Second Amendment right to get his gun rights back because he was convicted of a welfare fraud case 20 years ago. $2,000 he stole from the government in a welfare fraud thing. That's what he was convicted of, but therefore he doesn't get his gun rights back forever. That's what Judge Roth ruled in that panel, because it was a per curiam decision. All 3 judges on the panel, including Judge Roth, were on that panel. Now, this is what's telling. Today in oral argument, Judge Roth asked a series of questions. She asked a series of questions that to me I thought was quirky. And what I mean by that is Judge Roth asked a series of questions about whether or not Mr. Range actually had technical legal standing under Article 3 of the United States Constitution dealing with cases and controversies to even bring the case, even talk about these issues. The reason why this is kind of weird is that Judge Roth was on the lower court panel that ruled against Mr. Range. And she, in that panel decision, never made a reference that I can tell. She never talked about standing or Article 3 or any of these things when she was on the panel. So here, she's on the en banc panel with 14 other judges plus her to make 15 judges. And now, for some reason, she has found Jesus, if you will, on the issue of standing and is now asking these questions about standing. And where's that coming from? Why is she asking questions about the constitutional basis of these laws and whatnot? It seemed very odd, which tells me, as a professional trial lawyer, as an advocate, what it tells me is that she doesn't feel that she has the votes to affirm her panel victory down below. But the fact that, to me, she's trying to tank this case with questions about technical standing issues when she didn't do it when she was on the lower court panel tells me that she thinks she's going to lose and that the Second Amendment is going to be vindicated and that Mr. Range is going to win this case. So now she's looking for a way to kick the can down the road on the issue. That's my speculation. I don't know what's really going on there, but that's my best guess. So I think what's going to happen here is that Mr. Range is going to win. They're going to rule that indeed a welfare fraud conviction for $2,000 of a misdemeanor under state law 20 years ago is not a basis to deny this man his rights for the rest of his life. He's going to be entitled to get his right to keep. He's going to be entitled to get his right to keep and bear arms back. He's going to be entitled to have guns going forward. That is what I think the court's going to rule. But here's the other quirk about this. I think that we're going to see at least, this is my best guess, I think we're going to see multiple opinions. I think we're going to see some people that want to rule very narrowly and say, look, we don't want to get into the big issue about what constitutes dangerousness. For example, is embezzlement dangerous? Is fraud dangerous? Is DUI dangerous? Is check kiting dangerous? They're going to be a handful of judges, I think, are going to be like, look, we don't want to get into that. We don't need to. We can give Mr. Range his guns back without getting to all the natty hypotheticals and issues. We'll just do it in his favor and not get into these big methodological questions presented by Nyserpa versus Bruin. And then I think you'll have maybe 5 or 6 judges that are going to say, no, under Nyserpa versus Bruin, we think that 18 U.S.C. 922 G involving nonviolent felons and any kind of felons is unconstitutional as applied to people that are not deemed or not determined to be dangerous. I think you'll have a handful of decisions that say that a decision signed on by judges that say that, and I think there'll be a handful of judges that dissent. This is my best guess, and they're basically going to embrace the Department of Justice view, and they're going to be like, yeah, at the end of the day, Congress gets to determine who are law-abiding citizens and who are not, and we, the courts, have to defer to that. And if Congress thinks someone should not have a gun, then we're going to defer to that, and they don't get their guns. And I think that's how it's going to break down. 3 separate opinions, but at the end of the day, I think Mr. Range will get his Second Amendment rights back. I think he will be victorious. And then, of course, after that happens, will this case ultimately go to the United States Supreme Court? I think it's too soon to know that. We're not going to be able to analyze that in any robust way until we see the final ruling, and the ruling will likely come out, in my view, again, sometime in the next 3 to 6 months is my best guess. But again, at the end of the day, it's going to be up to the courts, and I don't control the courts, and they'll make their own choices, and whatever it is, it will be, and we will address it at that time when the opinions come out. Okay, folks, I hope you learned a little bit something today about nonviolent felons and the Second Amendment and the Range case. We'll be following this as we move forward. And if you haven't subscribed, please do so. We'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.